Thank you for coming out. It's a delight to be here. Thank you very much, Jeff, to you and to the college and to the Federalist Society for the invitation and the opportunity to come and to share with the group. As Jeff said, I am a full-time law professor, but I am also a part-time attorney. I practice civil litigation and also criminal defense. And before I went into teaching, I was a full-time criminal defense attorney up in the state of New York for 7 years. And as he said, I've titled tonight's talk, Tearing Down the Walls That Keep American Jurors in the Dark. He made a mention of the fact that I've written a book on the subject of the right to remain silent. And I've made a video on the same topic that apparently has gone almost viral. It's got over 20 million views at this point on YouTube. It's called Don't Talk to the Police. And in that video, I talk about some of the surprising reasons, as I did earlier today at the law school, why even innocent people ought to take the fifth, so to speak, should refuse to answer questions from the police, and all of the many surprising and counterintuitive ways in which even innocent people who tell the police the truth can often find that they've made the biggest mistake of their life, and actually help to give the police evidence that was used to convict them of a crime that they didn't commit. That happens more often than you would imagine. And today, in like fashion, I'm announcing the inauguration of a new nationwide campaign. I've been doing that continuously now for 10 years, and starting tonight here in Idaho, I'm giving a series of lectures around the country on the very subject that we'll be talking about tonight for the first time. This is the inaugural lecture, which we also intend to put on YouTube, so it'll be available to millions of people. So it's sort of like a dream come true for me, because as criminal defense attorneys understand, if there are any here, you'll know what I'm talking about. It's a very frustrating process to be a criminal defense attorney in America today, because there's so many things that you wish you could tell the jury. Things that the jury needs to know, that they deserve to know, that they have a moral right to know, but which our system does not tell them. In fact, our system intentionally leaves them in the dark by concealing from them certain fundamental and basic truths about the way the process works. Truths that are well known to every regular participant of the process. Every experienced criminal defense attorney knows them. Every prosecutor knows them. But by and large, most of them come as extraordinary surprises to jurors after the trial is all over, when they find out about things that nobody had told them about during the process. When professors like me in my line of work typically feel that there's things that ought to be more widely understood by members of the jury, what they'll typically do is write a law review article. They'll publish it. It'll sit unmolested on dusty law library shelves for decades, hoping in vain that somebody will pick it up and read it, and hoping that they in turn will hand it over to some highly prominent judge from the state Supreme Court, who perhaps maybe, if you're really lucky, will say, this makes a lot of sense, who will then perhaps make a recommendation to the state committee or the state council on jury instructions, who will then perhaps over time give some consideration to the possibility of writing a new pattern jury instruction so that the jurors might be apprised of all of this information. It is a long, elaborate, unpredictable process. It typically takes 30 to 50 years if anything happens at all, and usually it doesn't. Well, tonight I'm doing something altogether different. Unlike most law professors who waste their time writing stuff that nobody will ever see in the hopes that a judge might be persuaded to give that information to the jury, I'm going over their heads. I'm going straight to the American people. I'm cutting out the middleman, and I'm giving this information to you, future members of the jury, so you can share this information with other people when you find yourself someday soon, perhaps sitting in a jury room, deliberating with the others, and you'll have a chance to set them straight and to tell them all the exciting things you learned here tonight. So I want to begin with a quick passage from the scriptures. The good book says, acquitting the guilty and condemning the innocent. The Lord detests them both. And who could argue with that? Don't we all? But the problem is, tragically, it's not a secret anymore. Our legal system convicts way too many, far too many innocent people. But nobody knows for sure exactly how many. We're all familiar with the work of the well-known Innocence Project and other similar organizations that are laboring day and night around the clock to prove that people who have been falsely convicted of crimes that they did not commit, some of them serving life sentences, some of them on death row, DNA and other sorts of evidence being produced and located and brought to the attention of the courts in an effort to demonstrate that we've got the wrong guy once again. And it seems like almost, doesn't it? Every day you pick up the paper and somewhere in the country you read about yet another man, far too often a racial minority, being let out of prison with our sincere apologies. Whoops, looks like we did it again. And we got another one wrong. Terribly sorry. Here's a couple of bucks for your trouble. Sorry about all those decades you spent on solitary confinement or on death row. But we ought, as a nation, we ought to be doing more than just letting these people out with our apologies after 20, 30 years. We ought to be doing more. That's what I'm here to do tonight, and that's what you're here to do tonight. I'm deputizing all of you as part of my nationwide campaign to spread the message so that the American people can become better informed in these fundamental 10 points that if consistently understood and universally understood by every member of every future jury, will definitely result in fewer innocent people being convicted for crimes that they did not commit. And that's a good thing. Let me share with you these 10 surprises, I'll call them. These top secret surprises, although they're not really top secret. Of the 10 things that I'll be sharing with you in a moment, about at least 9 of them are undisputed and incontestable, uncontradicted, not even controversial, and in fact, you could look them up if you had time to go over to the law library at the University of Idaho and go browsing through all those thousands of books. Of course, you don't have the time. That's why the Lord sent me into your life. I have spent my life reading those books, so I can come and tell you what you would learn if you looked through them yourself. Surprise number 1. Eyewitnesses are notoriously unreliable, regardless of how confident they may appear, and their seeming level of confidence often has little or nothing to do with their actual accuracy. Now, this is not a matter of opinion. This is an undisputed fact. Psychologists who research in the subject of human cognition and human perception have documented this again and again with a veritable battalion of studies that confirm that eyewitnesses make mistakes on a regular basis, even the ones who claim to be extraordinarily confident. And we know this is true because I mentioned a minute ago that many hundreds of Americans have been exonerated. We call them exonerees, people who were convicted for crimes that they didn't commit and then released after DNA, for example, proved that they were innocent. Exactly how many innocent people have been convicted, we will never know. There's no way to know. There are many hundreds, at least nearly 1,000, that in fact have already been exonerated and released. But we know that they're just the tip of the iceberg, because the only ones who have any realistic prospect of getting out are the ones who, luckily for them, were falsely convicted of a crime where the perpetrator left behind some DNA, some biological sample that could be tested. And this accounts for a very, very small subset of all criminal defendants. The vast majority of all criminal defendants are convicted of crimes, whether innocent or guilty, for which there is no DNA that could later be tested. So we'll never know how many of them are languishing in prison for things that they didn't do. But studies have been done, as you would expect. Many professors and lawyers have said, well, how is it that we're doing this as often as we are? Because remember, we live in a country and in a legal system that has always given very generous lip service to the idea that we're not going to make any mistakes on our watch. We're going to bend over backwards to make sure that if there's any mistake is going to be made on our watch, it's going to be in the direction of mercy and leniency. The Supreme Court, in a case called Addington v. Texas, put it this way. They said, our society has chosen in the administration of criminal justice to impose the risk of error entirely upon itself. And this is why the Constitution, according to the Supreme Court, requires that no man may be deprived of life or liberty or property or convicted of a crime unless his guilt is proven beyond all reasonable doubt. Well, that standard was supposed to work in such a way as to make sure that if there was any room for doubt about the guilt of the accused, if it was a close case, we would find him not guilty. We would let him go free. And yet thousands of people have been falsely convicted for crimes that they did not commit. Researchers have gone back and looked at the trial transcripts of the people who were convicted, falsely convicted, later exonerated. And what do you suppose they found as the number one cause of false convictions? The answer was eyewitness testimony. They found that in 76% of all the cases that they looked at, some or all of the evidence against these innocent people consisted of eyewitness testimony. People who said, oh, I was there, and that's the guy, and there's no doubt about it in my mind. Let me give you an example of just how wrong an eyewitness can be. If you haven't seen it yet, let me heartily recommend that all of you take the time to look at a famous documentary called Murder on a Sunday Morning. It was a documentary produced by Home Box Office, HBO, an extraordinary and a riveting film, a riveting look up close at the American criminal justice system. A film crew from France had come over to the United States, and they wanted to follow a typical American criminal case from start to finish. By the most outlandish coincidence, they just happened to have picked this case. And such a case it was, an extraordinary case. A man and his wife, an elderly white couple visiting Florida from the state of Ohio. Tragically, this woman was approached by a young African-American who demanded her purse. When she didn't move quickly enough, he shot her and killed her right there, right in front of her husband. It was in broad daylight. Her husband was only about a foot away from the shooter. He had, one would imagine, an ideal opportunity to get a very close look at the face of the perpetrator, and not just an opportunity, but obviously the motive. When a man is pointing a gun at you and at your wife, needless to say, he's going to have and to deserve your undivided attention. When he called the police moments after the shooting, of course, the shooter ran off into the distance. He called the police. When the police arrived at the scene, he gave them a description of the shooter. He said it was a man of about 6 feet tall, approximately 20 to 25 years old. And these bumbling police officers, a disgrace to their profession, started driving around looking for an African-American. And the first one they found was a 15-year-old named Brenton Butler, A young kid, member of a good family, no criminal record, never been arrested, riding around on his bike on a Sunday morning. But because he was African American, they said to him, "Hey, young man, would you mind coming with us?" Tragically, the poor kid didn't have the good sense. He had not been taught by his parents to say, "No thanks, not without a warrant. Got to get back home. We're going to church. Sorry." But instead he said to the police, "Sure, I'll do it. Come along. Why not? I'll help out." He got into the back seat of their car. They drove him back to the scene of the shooting. They showed him to the victim, the man who had survived the shooting of his wife, and said, "Is this the young man?" He looked at him and said, "That's him." Didn't even come close to matching the description. He wasn't over 20, he was only 15. He wasn't 6 feet, he wasn't even close. But the police said, "Well, that's all we need to know. We're here, we got the guy." They locked him up, they put him in jail, and he spent more than 6 months in jail before he was finally released at the end of the trial, found not guilty, but he could have very easily been convicted of a crime that he didn't commit. I'm telling you this whole story because he doesn't look anything like the guy who committed the crime. There on the left is a picture of Brenton Butler, again, the 15-year-old who was picked up tragically because he made the mistake of being the wrong race in the wrong place at the wrong time. After he was found not guilty, months later, the police eventually, with the help of his attorneys, found the guy who actually committed the crime. His name was Juan Curtis. He was 24 years old. He was 6 feet tall. He nicely matched the description of the actual perpetrator because he was the perpetrator, and his fingerprints were found on the purse. Look at those pictures side by side. The man on the left is the one who committed the crime. The one on the right committed the crime. The one on the left was the one who was falsely picked up by the police and accused of a crime that he didn't commit. And yet, when this case went to trial, the man who saw the shooting from a distance of just about 2 feet in broad daylight sat there and testified under oath, "That's the man who shot my wife. There's no doubt about it in my mind. I'm absolutely certain." And look how terribly wrong he was. Keep this in mind the next time you're sitting in a jury and you're presented with the testimony of a witness who swears confidently and authoritatively and unequivocally, "There's no doubt about it in my mind." He might be right, but he might not be. And this brings me to my second point, surprise number 2. Our legal system tragically imposes almost no meaningful restrictions on the ability of lawyers, including both prosecutors and defense attorneys, to meet privately with the witnesses and to contaminate their memories in ways that will never be exposed at trial. It's a fact. It's a well-known fact, quite frankly, although it will come as a surprise to those of you who aren't intimately familiar with the criminal justice system. In case after case around the country, it's a commonplace. Witnesses, victims and other witnesses to criminal activity, when the first time they see a picture of the suspect, they say, "I'm not sure if that's the one. He might be, but I'm not sure." Then there's a lineup a little later, and now they look at his face again, same guy, and now they're testifying to the police, I'm pretty sure now." And yet, as sure as I'm standing here, by the time the case goes to trial, in case after case after case, that same witness, the one who wasn't too sure before, now she's testifying, "Oh, there he is. There's no doubt about it in my mind. I'm 100% totally certain. I see his face in my nightmares." How does this happen? In the ordinary world with which you and I are all intimately familiar, this thing doesn't happen. Anybody here find that your memories get better, more accurate, more vivid with the passage of time? Of course not. Outside the crazy, topsy-turvy world of the American criminal justice system, memories only get worse with the passage of time. But when you enter into the crazy world of the criminal justice system, it's like you've gone through the looking glass to a topsy-turvy world where everything is exactly the opposite of what you would expect. And memories consistently seem to get more vivid and more hardened as time goes by. How does this happen, and why does it happen? Let me give you an example of a famous, Ronald Cotton was another African-American man who was tragically charged and convicted of a pair of rapes that we now know that he did not commit. He spent more than 10 years in a North Carolina prison of a life sentence before DNA conclusively proved that he was innocent. 2 different women, tragically, white women, were sexually assaulted in their homes in the same neighborhood on the same evening. And when the police when their attention was drawn to him as a possible suspect, they showed pictures of him to these 2 different women. And one of the women said, "I'm not sure if that's him. He might be." The other woman said, "That's not him." That's right. One of the 2 victims said, "That's not him." And tragically now, 20 years later, we all know that she was right. Because now everybody knows, with the tragic benefit of hindsight, which is old as 2020, that he was innocent. Remember, DNA proved that later. But this same woman who said to the police, "That's not the man," by the time the case went to trial, both of the women said, "There's no doubt about it in my mind. I'm absolutely certain that he's the one." How does this happen? Again, it doesn't happen outside of the criminal justice system. But you won't know that if you're sitting in the jury, because all you get to see is the end product, the end result. You see the witnesses being brought in by the prosecutor. You say, "There's no doubt about it in my mind. I'm totally certain. It sounds absolutely reliable." And statistics confirm, not surprisingly, that ordinary jurors, when they hear this sort of thing, find this kind of evidence terribly persuasive. But part of the problem, like I said, is that we let lawyers meet with these witnesses and to mess with their minds in ways that have a sinister effect on the recollection and on the reliability of their testimony through the power of suggestion. Now, I'm not saying that there are no limitations. There are ethical codes, obviously. The American Bar Association has promulgated a code of ethics by which the lawyers must abide. But those codes are essentially meaningless in this particular context. All they say is that it is unethical for a lawyer like me, when meeting with a lawyer, to work with that lawyer to knowingly present false testimony. That's the one thing that is forbidden. So if I'm meeting with a witness, so I'm a prosecutor, I'm meeting with a witness, and she says, I'm not sure who did it. I can't say to her, well, listen, I need you to testify in the witness stand tomorrow that it was the defendant. You've got to say that for me. I can't do that. That's forbidden. That's unethical. It's worse than unethical. It's a crime. It's subornation of perjury. It's obstruction of justice. It's tampering with a witness. Those things are all highly forbidden. But it's almost a farce that we make those things forbidden, because those are not the kinds of abuse to which lawyers are most likely to succumb, because they're not terribly effective, quite frankly. No prosecutor or defense attorney in their right mind, even if the law allowed it, would ever say to the witness, well, listen, I know that it's a lie, but here's what I need you to say tomorrow. That witness would be a disaster on cross-examination. Just imagine. What would happen as soon as there was a little bit of prodding and poking on cross-examination, that witness would fold like a house of cards. But that's not how it's done. The way it's done most effectively is perfectly legal. It's perfectly permissible. Let me show you how it's done. A famous researcher, a psychology professor at the University of Iowa, did a study in which he took a large number of subjects and he asked them to watch a video of a simulated crime that was being committed. And then after they all watched the video, the same video, he gave them an array of photos of various individuals who looked like the guy in the video. And they said, can you pick out the guy in the video from one of these photos? The suspects, the participants in the study, presumably thought that they were being tested on their powers of recollection. What they didn't know is that it was actually a test on the power of suggestion. All of the individuals, the very large majority, nearly all of them said, well, I think it was this one. They didn't pick the same guy because, quite frankly, they were all wrong. The 6 photos that they were all shown, not one of the photos was the guy who was actually in the video. Not one. But almost everybody picked out one. Almost nobody got it right. Almost nobody said it's none of these people. Because there again is part of the problem with the power of suggestion. When the police, even in a simulation like this one, say, here's 6 different photos, the natural suspicion on your part is to imagine, well, I guess the police have reason to think that it might be one of these. And if you're asked to look at all of them simultaneously, your mind will play tricks on you, because you will naturally be drawn to the one who looks the most like the one who you saw at the scene or in the video, right? And then the longer you stare at that picture, soon your recollection of the actual guy's face starts to become distorted as it becomes conflated in your memory with the picture that you're looking at now. I know, it's outrageous. I would cry too. I feel like crying myself, brother. But that's where it gets really interesting. Let me tell you what he did next. After everybody in the study picked out one of the wrong photos, they were broken, unbeknownst to them, up into 2 groups. One group, the control group, was not given any feedback of any kind. Like, good job, attaboy, you got it right, you got it wrong. But they were asked a couple of follow-up questions. One of the questions they were asked was this: did you have a high level of certainty? How confident are you in the identification that you just made? How high was your level of certainty? And did you get a good view of the suspect? And here's what they said. The numbers were both fairly low. Those who were not given any kind of positive feedback, 14% of them, about 1 out of 10, said, well, the truth is I have a high level of certainty. And that's, by the way, as it should be. Don't forget, they were all wrong, okay? So I'm surprised it was even that high. These ones who were, yes, I'm absolutely certain, they didn't know what they were talking about. They were all wrong. But it was only 14%. 86% of them have the good God-given sense to say, well, no, I'm not that sure. And again, with good reason, because it turns out they didn't know it, but they were wrong. And only 28% of them said, well, I got a pretty good view of the suspect. But a second group was given positive feedback. The second group was told after they picked out one of the wrong photos, oh, attaboy, good job, you got the right one. Again, that was false information. It wasn't the right one. But when these people in this group, who didn't realize they were part of a study of this sort, were then asked the same 2 questions, look how the number changed. Extraordinary. 53%, more than half of the people in this group said, oh, wow, I had a very high level of certainty now that I think about it. Now, this is not how it ought to work. If people were perfectly 100% totally logical, just like Vulcans, the number should be the same. There's no reason for the number to be different. The second group, if it weren't for the power of suggestion, you'd expect the number to be almost identical. You would expect 14% of the people in the second group to say, well, I'm not surprised. I got it right. I'm not surprised. I was sure of myself. And you would expect 86% to say, well, I'll be honest, I'm surprised I got it right because I wasn't that sure. But that's not what happens. Look what happened. These people, in ways that they did not even perceive and understand, their mind started to play tricks on them. They were given information, false information, about the fact that they got it right. And so their mind starts to reconstruct reality, to line up with the information that they've now been given. And in effect, they began to reason subconsciously, oh, I got it right? Oh, well, was I sure? Well, come to think of it, now that you mention it, yeah, I was sure. Of course I was. That explains why I got it right. Did I get a look at the suspect? Oh, yeah, 56% of them said, real good look at the suspect. 58%. You see? And this sort of thing is what goes on behind closed doors all around the country, all day, every day, and all night, in ways that are not being videotaped for the jury to see anything about it at all. And this is perfectly legal in the American criminal justice system, which, by the way, is one of the most interesting contrasts between our system and the leading Western democratic European nations whose legal systems most closely resemble our own. The Germans, for example, among other European nations, correctly understand that this poses a significant threat to the criminal justice system. And that's why in Germany and several other European nations, there are severe restrictions on the ability of attorneys to meet privately, one-on-one, with the witnesses before the trial because of this danger. You see, so if I'm a prosecutor, or a defense attorney, with the best of intentions, I really just wanted to get justice done. There's no doubt about it. And I really believe in my heart that we got the right guy, and I believe that he's guilty. And I'm meeting privately in my office with a suspect or a witness, a key witness or a victim, not the suspect, but a victim or a witness. And I meet with her and I show her the photo of the defendant. I say, is this the one? You'll be called upon to testify tomorrow on trial. Let me just go over this one more time. Are you sure that he's the one? And she says to me behind closed doors, I think so. I can't say for sure. I'm pretty sure. I mean, I won't show chagrin on my face. I won't let her see from my look on my face that I'm horrified at her response because my case will be destroyed tomorrow. I'll never get a conviction if she says, I'm pretty sure. But that's not a problem. It won't be a problem. All I have to do is tell this woman or this young man, well, you picked the right one. We know that he's the one who did it. He's done it before. He's been arrested 2 or 3 times. The jury won't know that because we're not allowed to tell the jury about his criminal record. It's inadmissible under the rules of evidence. But he's been arrested a couple of times. Maybe they're never convicted, but he's been accused of the same sort of thing in the past. And there's other evidence against him that the judge won't let us use. And now she looks at the photograph. Oh, really? He's done it before? This guy? You know what's going to happen? What would you do? What would you think? Your mind starts to play tricks on you. Confirmation bias is what psychologists call it. And sure as I'm standing here, she's going to show up in court tomorrow and she's going to testify. The same woman who said at the preliminary hearing, I'm not so sure. She told the police originally I could be the guy. Or she originally told the police, like in Ronald Scott's case, that isn't the guy. But now, even though nobody has told her, I need you to lie, all I did was give her a little information. We know he's the one who did it. And because my confidence was so infectious and contagious, now she's sure that he's the one, and she'll be just fine for me tomorrow morning. That's why 71% of all false convictions are obtained in part on the basis, if not entirely, on the basis of eyewitness testimony. It's terribly unreliable. It's not always unreliable, but please explain these things to the other members of the jury. Next time you're in a case where the other members of the jury say, well, the evidence of his innocence seems rather substantial. His alibi seems pretty compelling, but she seems so sure. Well, maybe she is sure for reasons that you'll never know about. And the problem is, like I said a moment ago, these details and this background, the process leading up to her confidence level, will never be revealed to you at trial, in part because these earlier interrogations are never videotaped. And even if they were videotaped, there's no meaningful way that the defense attorney could bring this information to the attention of the jury. How would you cross-examine a witness like that? She's insulated from effective cross-examination. Because if I say to her on cross-examination, isn't it true that you're nearly, no, she'll say, I'm totally sure. Did the prosecutor tell you to say this? No, he didn't tell me to say this. She will testify sincerely and credibly because she's not even aware of how it is that her memory has been messed with or contaminated by the simple fact that she was exposed in passing to a couple of details that supposedly corroborated her testimony. Another way that it's often done, the prosecutor will say to the witness, she says, I'm not too sure. Well, you're not the only witness. There's 3 other witnesses who also say that he's the one. But unbeknownst to her, he's telling the same thing to the other 3. And simultaneously, unbeknownst to each other, they're corroborating each other behind closed doors and bucking up each other's level of confidence, even though they've never even met each other. And you can't say on cross-examination to the witness, isn't it true that you are only testifying that you're so sure about this today because the prosecutor told you about the fact that my client was convicted of doing the same thing 5 years ago? That's getting yourself out of the frying pan and into the fire, because then the jury thinks, he was convicted 5 years ago. That's all we need to know. You see the problem. But we're not done. Surprise number 3. False confessions are not an urban myth. We've heard the name, but they really do happen, and they happen with distressing frequency. The fact that the defendant confessed is not always reliable evidence of his guilt. Now, many defendants do confess, and most of them are telling you the truth. Most defendants who confess are in fact guilty, but not all of them. Out in Los Angeles just a couple of years ago, a young man named Felix was only 16 years old when he was brought in for interrogation by the police. Tragically, he had not seen my video or read my book. And so he agreed to answer the questions. He agreed to waive his right to remain silent. And he talked to the police for hours. He was interrogated. And for hours he said, I didn't do it. I wasn't there. I had nothing to do with it. Turns out he was telling the truth, but the police were unrelenting because they were convinced for some reason that they had the right kid. And after hours of interrogation behind closed doors that were not even videotaped, they eventually got this young man not just to give an oral confession, but to sign his name to a written confession. And it gets worse. The confession contained details that only the real shooter would have known. Stop me if you've heard of this one. At that point, it looks like a conviction was almost a sure thing. Once your client signs a written confession that supposedly contains details that the police will assure the jury we never gave him, he knew that on his own, a conviction is it's almost a foregone conclusion. And this kid was on his way, hurtling toward a murder conviction. When luckily for him, at the last minute, shortly before the case went to trial, his defense attorneys had the extraordinary good fortune to find out he had the mother of all alibis. On the day of the shooting to which he had confessed in writing, he was locked up in a juvenile holding facility. He was behind bars. He could not have committed the crime. Isn't that funny? And this was after the police officers in the same case had already insisted, we didn't give him any information about the shooting. Oh no, that'd be highly improper. But we know now that they had done that. Luckily for him, he had a great alibi. These things actually happen. I told you a minute ago about a study that was done that found that 76% of all false convictions for which people were later exonerated were based at least in part on eyewitness testimony. That same study found in a study of over 250 people falsely convicted, later exonerated by DNA, they found that 16% of them had confessed. 16%, more than 1 out of 10. Not a majority, no, that's true. But a significant percentage had actually confessed. And then every one of them went to the trial, and every one of these people testified and said, no, it is true, I told the police this, but they threatened me, they worried me, they frightened me. And when you're an ordinary member of the jury and you don't know much about the way the system works behind the scenes, your natural reaction is to think, oh, come on, kid, you expect us to believe you. You told the police you did it, and you really didn't do it because you were afraid of their threats. The officer seemed so pleasant on the witness stand a minute ago. He didn't seem to be threatening at all, not to us, no, not to you. You weren't alone with him, being yelled at across the table in the middle of the night after 4 hours of being separated from your parents and a lawyer. So when the other members of the jury back in the jury room say to you, what else do we need to know? The kid confessed. That means he's definitely guilty, obviously guilty. You've got to explain to them, no, that's not necessarily true. 16% of all innocent people falsely convicted in America, and there are thousands of them, also confessed. It does happen. I'll give you one more example. Remember Brenton Butler, the young 15-year-old I told you about, who was almost convicted of a crime that we know now that he didn't commit, based in part upon faulty eyewitness identification? He also confessed in writing. After he was threatened with physical violence by a police officer behind closed doors, he signed a written confession. We know now that he's innocent, but he confessed too. It really does happen. Surprise number 4. What about the silence of the accused? Suppose you're sitting in a jury someday soon. And I think I speak on behalf of all of the criminal defendants and suspects and criminal defense attorneys in the state of Idaho and their family members when I say, I hope to God that many of you will be on juries soon. What happens? What if you learn during the course of the trial that the defendant was approached by the police before the trial started? And he was asked if he would answer a couple of questions, and he respectfully declined. He exercised his constitutional right under the Fifth Amendment to remain silent. Or you see at the trial, he doesn't testify. He just sat there. He didn't testify. He could have testified, but he didn't. I mean, that fact you will obviously notice. Is that reliable evidence of guilt? Is it compelling, conclusive evidence of guilt? More than 50 years ago, the United States Supreme Court correctly noted that the average reaction of the ordinary citizen, even those who ought to know better, is to think that, well, if somebody's not going to take the witness stand, I think that's pretty much all we need to know. I'm just paraphrasing, of course, but that's what the Supreme Court said 50 years ago. But that's not true. The Supreme Court of the United States has said repeatedly in case after case that there are many perfectly natural, innocent reasons why even innocent people will refuse to talk to the police before the trial begins. One of them, of course, is the video that I made on the same subject, which now has over 20 million views. So if you learn that somebody in a case that you're trying didn't talk to the police, maybe it was on me, maybe it was my fault. Or maybe it's because he read about how it was that the Supreme Court has said, in the opinion of Justice Robert Jackson, the former Attorney General of the United States, was an Associate Justice of the Supreme Court in 1949, when he wrote that any lawyer worth his salt will advise his suspect, his client, not to talk to the police under any circumstances. And this comes from the former Attorney General of the United States. So don't think that, if he's innocent, of course he'll talk to the police. That's absolutely not true. And don't think that if he's innocent, he'll take the stand at the trial, and therefore his silence, is pretty reliable evidence of guilt, because that's not true. Another study of hundreds of people who were exonerated after being wrongfully convicted found that 39% of them, more than a third, close to half, about 2 out of 5, did not testify at their trial. I got to pause and let that sink in. People that we now know to be innocent, beyond a shadow of a doubt, and 40% of them, when they had the chance to testify at the trial, did not do so. I would not blame you if this strikes you as absolutely mind-boggling. No matter how sophisticated you may be, if you're not intimately familiar with the criminal justice system, your natural inclination would be to suspect, well, for crying out loud, if the guy is innocent, why in the world wouldn't he take the witness stand? I don't have time to give you all the reasons, but any experienced criminal defense attorney can explain to you, there are so many reasons. As the Supreme Court itself has often said, it may be, after meeting with the client, that I come to the conclusion, this guy doesn't make a very convincing witness. He says he's innocent. I believe he's innocent. I even know that he's innocent, but he seems evasive. He's nervous. And why wouldn't he be nervous? He's facing the death penalty. And we've practiced this testimony a number of times in my office. He's not terribly articulate. He's not terribly convincing. He sweats. He shakes. He's nervous. He can't make direct eye contact. He's not terribly eloquent. I don't think the jury's going to believe him. That's one reason. Another possibility, just as likely, that I've met with my client privately, and he's told me several times, I wasn't involved in the shooting, but I was there. So if he takes the stand and tells the truth, he's going to put himself at the scene of the crime. He's going to have no choice but to admit at least one of the things that the government wants the jury to conclude. That doesn't mean that he's guilty, but that may be a good reason not to put him on the witness stand. A third reason, often under the rules of evidence, defense lawyers find themselves in a position where the client has a conviction, perhaps in the distant past, because 10 years ago, he was convicted of a felony somewhere across the country when he was much younger. He's turned over a new leaf. He's found the Lord. He's gotten religion. He's got a job. He's got a family now. He's a different man altogether. And under the rules of evidence, the jury won't learn anything about that earlier conviction unless he testifies. But the judge says to the defense attorney, well, Mr. Duane, I'm sorry, but I think I agree with the prosecutor. If your client chooses to testify, which is his constitutional right, I think it's only proper that I let the prosecutor on cross-examination ask him in front of the jury about all those earlier convictions of those terrible things he did out in Nebraska. And frequently, nobody knows, but countless times, thousands of times, every year, all around the country, criminal defense attorneys say, well, with all due respect, that's a risk we cannot take. I would rather put my client on the stand. He would rather go on the stand. But if the price that we've got to pay for his testimony is that the jury is going to learn about these highly prejudicial details of his earlier criminal record, that's not a risk we can afford to take. So please, please don't think that just because he doesn't take the stand, well, that pretty much proves that he's guilty. It does nothing of the sort. So many reasons why innocent people choose not to take the witness stand. You need to explain that to the other members of the jury, because I won't be there. Although hopefully you'll be able to sneak a laptop into the jury room so you can play this video on YouTube to the other members of the jury, and don't tell the judge you're doing it. Surprise number 5. The framers of our Constitution, this is not, by the way, my opinion. This is a documented, undisputed historical fact. The framers of our Constitution, the folks who wrote the Bill of Rights, intentionally wrote it in a way to protect your ability, as a member of the jury, to serve as a protection against the ability of corrupt government officials to oppress the innocent through the exploitation of unjust criminal laws. And it's not a surprise that they did that, because remember, the founding fathers who wrote the American Constitution were still intimately smarting from their personal, vivid acquaintance with what it was like to suffer under the oppression of a British government that did, in fact, exploit the criminal justice system in just this way. The Supreme Court of the United States in 1968, in explaining why there is a constitutional right to trial by jury, wrote the following words. They said, the function of the jury is to prevent oppression by the government and to protect against unfounded criminal charges brought to eliminate enemies and against judges who are too responsive to the voice of higher authority. More recently, in 1986, the Supreme Court said that this power of the jury is to serve as, quote, a check on official power, which is, in fact, quote, its intended function. Now, although I've avoided the word until now, most of you know I'm talking about what is often known pejoratively and loosely in the colloquial version as jury nullification, which is a phrase that, of course, has gotten a lot of bad press, particularly from prosecutors and judges, who will tell you, if you ask them, there is no such thing as valid jury nullification all around the country. When jurors raise their hands and say to the judge, Your Honor, what is this nullification thing? One of the other jurors told us about it. I read something about it in the paper. I know what the judge will tell you. He will lie to you. He will say to you, there is no such thing as valid jury nullification. It is forbidden. It is illegal. It is unconstitutional. It is unbiblical, un-American. And it is none of those things. The Supreme Court of itself of the United States wrote in Greg v. Georgia in 1975 that our system of criminal justice, in our system of criminal justice, the discretionary of jury nullification must be allowed. That's how you serve as a check on governmental abuses and on governmental power. If you had no right to nullify unjust laws, if you had no choice under the law but to vote guilty, even if your common sense told you, good God, it doesn't make sense to me that anybody ought to go to prison for this. And by the way, you would be amazed at how many laws on the books no longer coincide in any way with anybody's God-given moral sensibilities. Did you know it's an offense under federal law to transport the seeds of a water hyacinth across state lines? Did you know that? Even if you don't actually take one of the seeds, if you advertise in the paper that you are willing to transport the seeds of a water hyacinth across state lines, you've just committed a federal offense. Did you know it is a federal offense and you can go to prison for 6 months if you possess or transport margarine in a plastic tub, more than 1 pound of margarine in a single tub? If you break it up into separate tubs, you're good. But you put more than a single pound of margarine in a single plastic tub, you can go to prison for 6 months. And these are just 2 of the more than 10,000 criminal statutes on the books today. We've come a long way from the days of the common law when there were approximately only about a dozen felonies for which you could be prosecuted. If you find yourself someday in a jury, and to your amazement, you can't believe your ears, when you hear the government tell you and the judge tell you that the defendant is on trial for something that your common sense tells you nobody ought to be able to go to prison for that. That can't be criminal. That can't be a crime. That's not intrinsically dangerous. That's not a peril of any sort to the general public morals or to the safety of the community. But the judge tells you, I'm sorry, ladies and gentlemen of the jury, if you find that this defendant was knowingly in possession of 1 pound of butter in a margarine, not butter, butter's okay. If you find that this no-good, dastardly smuggler was knowingly in possession of that 1 pound of margarine in a plastic tub that we found in his trunk, you have no choice but to vote guilty. You must vote guilty. You have no choice. Your hands are tied. That's not true. The Founding Fathers said no. In a case like that, it is your constitutional authority and your responsibility to say no. Not on our watch. We are not going to serve. How can we serve as a bulwark against tyranny and oppression if we have no choice but to vote guilty when our common sense and our moral instincts tell us that it is outrageous that you're prosecuting a guy for doing a thing like this? You have the right to nullify. And that was reflected intentionally in the design of the Constitution. That's why the Double Jeopardy Clause says that if a man is found not guilty by you and by your peers in the jury room, that's the end of the matter. There can be no further trial. And the Due Process Clause says there can be no appeal on the part of the government, nor does the judge have the power to throw your verdict out because he doesn't agree with it. That's also written into the Bill of Rights. So your decision is final and unreviewable. And the Constitution also provides, in case you didn't know it, that the judge cannot and will not ask you when you come back with your verdict, if you vote not guilty and he's outraged by your verdict and he thinks this is outrageous because he is personally convinced, beyond a shadow of a doubt, that the guy knew all about the margarine. And the judge says, before you go, I need you to explain to me, how in the world could you find this guy not guilty? Can you give me an explanation? You have the right under the Constitution to say to the judge, Your Honor, with all due respect, nope, we're going home. And he cannot stop you. He cannot detain you. He cannot interrogate you. He cannot punish you for the fact that you voted not guilty. And it doesn't matter how overwhelming the evidence may be in the opinion of these governmental officials who may be, as the Supreme Court wrote in 1968, a little too sensitive to the voice of higher authority. You have the power to nullify. The judge will say that I'm wrong. He'll deny it. But he's lying to you. Number 6, unless the judge tells you, and he usually won't, you don't have the faintest idea. You think you do, I know, it's not your fault. It's not your fault. But you don't have the faintest idea what the defendant's possible sentence will be if he is convicted. And, I might add, you definitely cannot trust that bully, loudmouth foreman on the jury who's sick and tired of the fact that you won't acquiesce and capitulate to the others. And so he's trying to browbeat you into helping them reach unanimity by giving you his expert opinion on what will happen to the defendant if we vote guilty. All around the country, every year, year after year, there are countless cases where a jury comes back, they vote guilty, they announce to the judge that they are unanimous, and then 1 week later, one of the jurors, or 2, or sometimes 3 of the jurors, they call up the defense attorney, or they write to the judge, or they go to the judge's office, and they say, Your Honor, we just heard in the paper yesterday what happened. We just heard that this guy was sentenced to prison. We can't believe our ears. We didn't think he was guilty. We thought he was innocent. We didn't think that he approved his. We only agreed at the last minute, after hours and hours of browbeating by some of the other members of the jury. We finally capitulated and gave in because one of the other jurors told us that he would never go to prison for very long. But we didn't know. We trusted him. Let me give you a couple of examples of this. I could do this for hours, but I promise I won't. Let me just give you a couple of quick examples. In Indiana a few years ago, the government prosecuted a man named Kenneth Lewis. The evidence against him was circumstantial, as the Court of Appeals admitted. The charge was that he had possessed more than 50 grams of cocaine with the intent to distribute it. Less than 3 ounces, well, approximately 2 ounces. That's not a great quantity by any means. 50 grams is an extraordinarily small amount of cocaine. But the government prosecuted him and tried to prove that he was in fact in possession of this crime. The testimony, by the way, against him consisted primarily of the intrinsically suspicious testimony of his so-called accomplices. A couple of his partners in crime testified in front of the jury how, oh yeah, we were working for Mr. Lewis. Kenny, he asked us to go get the stuff, and we were doing it for him. This was the heart of the government's case, rested on this testimony, which, as I said, is intrinsically suspicious, because when these accomplices cut a deal with the government, as they did in this case, almost invariably, their motives are suspect because in this case, as in most of these cases, they were hoping that because of their favorable testimony against this guy, the government would drop or reduce the charges against them, or they would get less time in prison on their case, as a result of the fact that they gave the government substantial assistance in this other case. So the case against him was far from overwhelming. It was not a slam dunk, and even the Court of Appeals admitted it. During the trial, the defense attorney in that case, the attorney for Mr. Lewis, made a perfectly reasonable request. He said to the judge, in effect, Your Honor, you know, and I know, and the prosecutor knows, that if the jury finds this young man guilty of possessing 50 grams of cocaine, he will go to prison for life. No chance of parole. Mandatory. He will spend the rest of his life in a cage. He will never know marriage, the joys of parenthood. He will never be a grandparent. Can we just tell the jury that much so they can take that into consideration? And the judge said, no, I will not allow that. I wonder if you had been in that jury, and they were not allowed to learn that particular detail, and the jury did find him guilty, and the conviction was affirmed on appeal, and that man will be in prison for the rest of his life with no chance of parole, in a case that was admittedly a closed case that could go on either way. How many of you would be surprised if you were in a jury to find out 2 ounces of cocaine? Mandatory life in prison? That's what happened in that case. Charles Lynch was a man who was convicted out in California for growing marijuana on his own property. It was a state that had already passed various laws that made it legal under state law. And the California legislature and the Constitution had both been amended to make it legal, as far as California authorities were concerned, to grow marijuana on your own property. So he went ahead and did it. He did it openly. He contacted local, state, and government officials to make sure he was doing it by the book. He even called an agent of the Federal Department of the DEA, the Drug Enforcement Agency, who told him over the phone, we're going to just defer to the local authority figures. Do whatever, as long as they're good with it, we're not going to bother you. He thought he was good to go. He did this openly and notoriously. The federal government, for whatever reason, decided they were going to prosecute him, and they did. He was arrested, he was charged, and the jury at his trial, he offered evidence that, well, I was doing this thing openly. I wasn't trying to hide this anywhere. I brought it to the attention of the authorities. I even contacted the DEA. But the trial judge in that case said to the jurors, it doesn't make a difference. That's not a defense. If you find that he did it, even though he did it openly, and he was assured by the DEA that it was okay, you must find him guilty. He didn't tell them about their power to nullify an obviously unjust law, and they found him guilty. When the man was sentenced, the judge in this case said, well, I'm not going to put him in jail for more than a year. It was obvious to me he didn't think he was violating the law. It was obvious to me he was doing everything he could to try to make sure that he was all squared away with the state and local authorities. The law on the book said, because of the amount of marijuana that was involved, he supposedly had no choice but to give the man 5 years in prison. And the judge said that would be unconscionable, that would be unjust. I'm only giving him a year. The Department of Justice appealed in that case. An organization that has the audacity to call itself the Department of Justice decided, no, a year is not enough. And they went to the Court of Appeals, which reversed the lower court and sent it back and said, no, you have to give him 5 years. Even though you think it's terribly unjust, you've got to give him 5 years. How many of you would think in such a case, if you were in the jury, that a man could go to prison, must go to prison for 5 years if you find him guilty of possessing marijuana under circumstances like those? In a case out of Ohio, a man named Ryan Collins was convicted for the possession of certain child pornography that was found on his computer. There was no evidence that he had created any of this material or anything like it, or that he had ever actually been in the presence of any of the children or any other children who were being victimized in this way. But admittedly, it was a serious offense. The jury found him guilty. The judge in that case did something quite unusual. He asked the jurors, he surveyed them before they left, before they went home. He said, I just wonder, you've heard all the evidence. You're the ones who voted to convict this man. What do you think a proper sentence would be? And the jurors who had heard every intimate detail of the evidence against the man recommended a sentence of 14 months in prison. What they didn't know was that under the federal sentencing guidelines, the appropriate sentence was 20 years. Again and again, the truth is, and these aren't even the worst cases. Out in California with the famous 3 strikes laws that many of you have heard about, a man was sentenced to life in prison for stealing a pair of tube socks because it was his 3rd offense. Another man out in California was sentenced to life in prison because he was guilty of joyriding. He stole a car and drove it around for a little while and then he left it off somewhere. Life in prison, mandatory life in prison. But the judge won't tell you these things in most states, and in federal court, they won't tell you anything about it at all. You're being deprived of information that you really ought to know, which, by the way, takes me to my next point, point number 7. If you are in the jury, you have a moral right and the moral duty to know what the sentence will be, that the sentence may be facing if he is convicted. Now, for the sake of full disclosure, I will admit to you that the Supreme Court says I'm wrong. But I will also tell you that I'm right. And they are wrong about this. Of the 10 surprises and secrets that I've shared with you tonight, this is the only one that is a matter of opinion. This is the only one that is really controversial or disputable, even in theory. The others are all undisputed, documented fact. But even this one I'm right about. The Supreme Court of the United States has held again and again that jurors are not supposed to be told about the consequences of their verdict and what it might mean for the defendant and for his family. And, for example, how many years he might get in prison. The most famous example of this, the most famous case, not that long ago, there was a case decided by the Supreme Court called Shannon versus United States. Terrible case. Mr. Shannon was arrested and charged with the open possession of a firearm. He was seen walking around with a gun, a loaded firearm in public, which is obviously a hazard to the general public. He was arrested. He was charged for this crime in federal court, and his attorneys pled the defense of insanity, which is a perfectly viable defense. We all know that not everybody who claims to be insane is insane, but some of us are. It was a perfectly respectable defense. That's what the case was all about. They did not dispute that he did the things for which he was on trial. All they wanted to do was to ask the jury to consider with an open mind the possibility that it might be entitled to an acquittal under what's called the not guilty verdict. Now, at a trial like that where the defendant claims that he is not guilty, the jury is told, you've got a couple of choices here. You can find the defendant guilty, or you can find him NGI, which stands for not guilty by reason of insanity. That was the choice that the jury was given. Mr. Shannon, in that case, made a 100% perfectly reasonable request, a modest request, a request that should have struck the jury as the judge as perfectly sensible and uncontroversial. He said to the judge, Your Honor, you know, and I know, and the prosecutor, we all know that if the man is found not guilty by reason of insanity, he won't go free. He won't be put back out on the streets today. But the jury doesn't know that. And the defendant's attorney in that case presented the Supreme Court and the district judge with impressive statistical evidence showing the unsurprising fact that many average Americans on the street, who ought to know better, but it's not their fault, they have the impression perhaps from television or from the movies, gosh, if we find him not guilty because he's insane, does that mean he walks out the back door waving guns in both hands as he runs out and posing additional peril to the community? If that's the misapprehension under which some of the jurors are laboring, it's obvious that the chances can only go up. Perhaps drastically they will convict this guy. Even if they're otherwise inclined to think that he really is insane and to accept his defense, if they know that he's engaged in conduct that is a danger to the community, you might well expect, of course you would, that they'll be tempted to err on the side of caution and to reject his defense and to convict him if that's the way to keep him behind bars. Well, that's not the truth. If a man is found not guilty by reason of insanity, he's not released. He's committed to the custody of the Attorney General to be held in a hospital behind bars until he's safe to be released to the community. And that's all the defendant wanted the judge to tell the jury. Incredibly, the Department of Justice opposed that request and said, no, that jury should not be given that information, which to me is outrageous. If I were the prosecutor in a case like that, I'd say to the judge, of course, give that information to the jury. I don't want to win this case that way. I don't want to win the case by preying upon the ignorance of the jury or by exploiting the fact that they've been left in the dark. But our federal government, your federal government, the Department of Justice, fought all the way to the Supreme Court where they won on this question. And the U.S. Supreme Court in that case announced that the jury is not supposed to be told anything about the consequences of their verdict, including sentencing, for example. No, that's not their job, the Supreme Court said. Their job is one thing, to decide based upon the facts whether the defendant is guilty beyond all reasonable doubt. But with all due respect to the Supreme Court, which in this case is not much, what the Supreme Court is insisting in that case is literally incomprehensible. It is literally absurd. Because remember, the Constitution, according to the Supreme Court, says that you're not supposed to convict a man. You cannot convict a man unless the jury has been unanimously persuaded that he is guilty beyond a reasonable doubt. Well, what does that mean? As prosecutors invariably love to remind the jury at the end of every criminal trial, my job is not to prove that he's guilty beyond all doubt. Nobody's guilty beyond all doubt. We just have to prove that he's guilty beyond all reasonable doubt. Well, what does that mean? What it means is that the level of uncertainty that the jury finds that they are left with, guilty beyond all reasonable doubt means that we do have some slight uncertainty, perhaps about the possibility that we're making a mistake. But the level of uncertainty that we have at the moment doesn't strike us as sufficiently great that it is a good enough reason to hesitate to convict. It would be unreasonable for us to hesitate to convict this man based upon the fairly minimal level of uncertainty that we have. But that is an incomprehensible assignment. If you're sitting in a jury and the judge says to you, here's the evidence against the defendant, we want you to come back and tell us whether he's guilty beyond all reasonable doubt. Suppose you were in the jury and you knew after having heard the evidence, like the case I told you of Kenneth Lewis, remember, where the government relied almost entirely upon the testimony of his accomplices, and you're thinking to yourself, well, he's charged with 2 grams, possession of, not 2 ounces of cocaine. We're not totally sure beyond a reasonable doubt. Nobody in their right mind is going to say beyond all doubt that we can definitely trust these accomplices who admit that they're hoping to shave some time off their sentences. They have an obvious motive to exaggerate, to blame him, to save their own necks. We can see why they might well be lying, but then again, they seem pretty convincing and they seem pretty sure of themselves. Is that proof beyond a reasonable doubt? You tell me. If you were in the jury and you knew that the worst thing that would happen to this guy, for goodness sake, is that he get probation for a couple of months, I think most of us might be tempted to think, that's good enough. If that's the worst thing that could happen to the guy, if that's the worst case scenario, I don't think it would be reasonable for us to hesitate to convict this man. But what if you learned in that same case, as was the case, that if we find this man guilty, he's got to go to prison for the rest of his life with no possibility of parole? A sensible, rational individual in that same jury room is going to say, whoa, that's a horse of a different color. Now that we know that the man that we're being called upon to decide whether he's guilty or innocent, we're on the verge of deciding whether this man will be deprived of his liberty for the rest of his natural life. Now, can we honestly say that this evidence of the testimony of his accomplices is enough to convince us beyond all reasonable doubt? Or that it would be unreasonable for us to hesitate because of our uncertainty? You know what you would do, and so would I. We'd say, well, that's another matter altogether. The truth is, that's how moral reasoning works, both in the criminal justice system and in our ordinary workaday lives. When you're trying to decide whether it's okay to buy this pencil or this car or to get on this amusement park ride, we always take into consideration, well, what are the odds that I might get hurt if I buy the pen? What are the odds I might hurt if I fall off the roller coaster? And what are the odds that that'll happen? That's how we reason about whether your friends are being unreasonable when they say, well, I don't think it's safe to get on an airplane. I don't think it's safe to get on this ride or to get in a motor vehicle. In assessing whether these people are being illogical or irrational or unreasonable, we have to take into consideration, well, what's the stakes that we're talking about? Is there a danger that you'll sprain your finger? Are we talking about a risk that you'll actually get killed? Because if there's a risk that you'll get killed, or that somebody will be killed, well, then maybe only a 1 in 500 chance all of a sudden does seem unacceptable, unacceptably great, unreasonable. Or in other words, it would be a perfectly reasonable basis for hesitating to take further action. So what the Supreme Court has asked you to do is incomprehensible. Unfortunately, however, this is what the Supreme Court has held. So if you are in a jury someday and you send a note out to the judge, and the judge will tell you, if you have any questions, send me a note. And you say, Judge, we've been talking back here about what might happen to this guy if he's convicted. And one of us says he'll probably get probation. And another one says that he knows for a fact that the defendant's going to go to prison for life. Can you just tell us what the answer is? The judge will come back to you every time and he'll say, no, I will not. I cannot tell you. It's none of your business. You have nothing to say in the matter. All you have to do is to get back there one more time, give the old college try until you're unanimous, and you come back and you tell me whether he's guilty beyond all reasonable doubt. But don't ask me what your decision will mean for this man and for his future, because that's no concern of yours. This is incoherent. That's not moral reasoning, but a sham. Nobody can engage in any systematic, meaningful discussion of whether we are faced with a reasonable risk of serious mistake, unless we know what the consequences might be of a mistake on our part. But we systematically deprive the jury of this information. So what's the bottom line for you future members of the jury? I'm telling you right now, here's what you need to do. You need to proceed for the purposes of your deliberation on the assumption that a guilty verdict could well mean that this guy will get life in prison. A man in California got life in prison because of the illegal possession. He stole a pair of tube socks. You don't know anything about the extent of the defendant's criminal record. And you don't know anything about the federal sentencing guidelines and how they apply to this case. In Norfolk, Virginia, where I live, a man was recently found guilty by a jury of possessing it with the intent to sell 5 grams of methamphetamine. That's all the jury was asked to decide. Do you find that he possessed at least 5 grams? And they said yes after hours of deliberation. Unbeknownst to those jurors then, what happened next is a commonplace tragically in America today. After the jurors were sent back home and with the judge's thanks, the judge then rolled up his sleeves and said, all right, let's figure out now what the sentence ought to be. And a sentencing hearing is then held without the jury and without the rules of evidence. And at that hearing, the judge decided, based upon hearsay that was presented to him, that the actual amount of cocaine and methamphetamine that was possessed and trafficked by this defendant was well over 450 grams, which under the federal sentencing guidelines meant that he would go to prison for 20 years. I wonder how many of those jurors had any idea when they went back to deliberate that if we find this guy guilty of possession of merely 5 grams, which is approximately the weight of a dime, that he may go to prison for 20 years. But we kept that information away from them. Likewise, they had no idea that after they were gone, the judge would get down to the business based upon their verdict of deciding what else. Oh, and in that same case, by the way, the jury heard no evidence that the man was ever in possession of a gun. But during the sentencing hearing, the government brought in an agent who said, well, I never saw him in possession of a gun either. But I talked to various witnesses who had spent a lot of time with him, and one of them, only one of them, told me that he once saw the defendant with a gun. The defendant had no chance to cross-examine the witnesses against him, because unfortunately for him, the right to confront the witnesses against you doesn't apply in a criminal case. But the judge found that testimony was believable. And the judge said, I find that he did have a gun. That's my opinion based on my finding of a preponderance of the evidence. And under the federal sentencing guidelines, that means a couple more years in terms of the recommended sentence. And again, as I said, that man ended up getting more than 20 years because a jury was persuaded to sign a piece of paper that said, well, we think he possessed 5 grams, about the weight of a dime. That's the way the American criminal justice system works today. You folks in the jury, the folks who are given the constitutional assignment of serving as a bulwark against a tyranny and a guarantor of fairness, you've been reduced to the virtually meaningless role of listening to a little bit of evidence and saying, well, gosh, it just sounds like harmless fun. It doesn't sound like a terribly serious threat to the general public. 5 grams? Sure, where do we sign? That's what he did. And then after what you don't know is that you have unwittingly just given the federal government and the judge the green light to now take a look at all kinds of other evidence you haven't even seen in an effort to decide for themselves exactly how serious this crime was and how many drugs were involved and whether guns were involved. Questions you'll never be called upon to make an opinion about. And that will determine the actual sentence that will be imposed upon this guy. Surprise number 8. Surprised yet? No matter what the other members of the jury may tell you, there is almost nothing the court can do to overturn your verdict just because they think the decision was wrong, even if the judges are nearly certain that you were mistaken. Let me give you an example of another real-world horror story, with my apologies for sharing so many horror stories. But what you can find on the pages of any law library is more terrifying than anything that ever came from the pen of Stephen King or Stephen Breyer. In Norfolk, Virginia, my hometown, just a couple years ago, a man named Joshua Wood was charged with murder. After an extended trial and extended deliberations, the jury came back with a guilty verdict, as jurors usually do. In federal court, by the way, 78% of all cases that go to trial, the jury finds the guy guilty. And that's after 90% of the others have already pled guilty. He was found guilty. And then something extraordinary happened. This is a quote from the local newspaper. One of the jurors said that she struggled with the decision. At one point, she considered walking out and causing a hung jury in a possible retrial because she did not believe the prosecutor had made his case, said Mimi Smith, 43, a former healthcare worker. Bless her heart. This woman, to me incredibly, has no apparent compunctions about being identified by name in the paper. The same article goes on to say that she agreed to convict only after the jury foreman told her the judge could overrule our verdict if the judge feels that we made a mistake. When the foreman told the jury the judge could overrule a decision that she thought was wrong, Mimi Smith said, okay, I'll convict. That's what she said, persuaded her to change her mind. And the reason why this became, if the story had ended there, tragically, I doubt that anybody would ever know anything about this. Joshua would have spent the rest of his life behind bars or maybe sentenced to death. But all of this became public knowledge because of a bizarre coincidence, an extraordinarily improbable coincidence. When this trial was over, the defense attorney, as defense attorneys always do, made a motion to the judge, asking the judge to throw out the jury's verdict. The judge has an extraordinarily limited power in a criminal case. At the end of the trial, if the judge thinks the verdict was absolutely indefensible, the judge has an extraordinarily limited power to say, I'm not going to, even though the jury found him guilty, I'm going to let him go free. And as if to prove that age-old aphorism that a little knowledge is a terribly dangerous thing, the jury foreman in this case apparently was vaguely familiar with that particular notion, and he shared that information with the other members of the jury. He said, look, if you're worried about whether we're maybe making a mistake, don't worry about it. The judge heard the evidence, and if she doesn't agree with us, she'll throw it out. Well, mirabile dictu, that's exactly what happened in this case. The defendant made the motion, and the judge, an excellent judge in the city of Norfolk, a former prosecutor named Karen Burrell, she stunned the attorneys when she announced, I'm granting the motion. She said, I sat through this entire trial, and I don't see how any rational jury could have found this man guilty of murder based upon this evidence. I'm therefore throwing out the verdict. And it was at that point that the members of the press scurried to find the members of the jury to ask them what had happened. That's how they found Mamie Smith. And to get back to the article, it says, when she was told that the judge had thrown out the conviction, Ms. Smith told the reporter, I'm glad she made the decision. That's incredible. I'm astounded, as I said, that this woman, God bless her, is willing to let herself be named in the paper by name. She has no idea. She's clueless. She seems to apparently think that, oh, this is a happy result. This proves that the system works. What great news, what grand news. No, it does nothing of the sort. What she doesn't understand, and probably nobody in my hometown who read this article understands, that this was the most wildly improbable coincidence, that the judge would actually throw the verdict out in the same case where one of the other members of the jury said, oh, that's what the judge will do if she thinks we're wrong. No, I'm here to set the record straight. That's a terrible mistake and a terrible misconception. Judges, both the trial judge and the appellate judges, do not have the power to throw the verdict out just because they've looked over the trial transcript and they're personally convinced that the guy was not guilty. They can't do that. If they do, they'll be reversed by a higher court. No, under the law, even if the judge is pretty close to certain that an innocent man has been wrongfully convicted of a crime, and she's quite astounded that the jury reached this particular verdict, she cannot toss out their verdict willy-nilly unless she can honestly say that this evidence of his guilt was so utterly insubstantial that there is no way that any rational jury could have found this man guilty, you see? Even if the judge says, I'll be honest with the attorney, it says to the attorneys after the trial, I'll be honest, I'm amazed at the jury's verdict. I never thought they would convict. There's no way I would have convicted. I can't believe that they did it, but I can't say that no rational jury could have chosen to believe this testimony. I thought the testimony was utterly incredible, but I can't say there's no way that his accomplices couldn't possibly be telling the truth. I'm not allowed to grant this motion and throw out their verdict. But in case after case, when somebody is holding out and standing in the way of unanimity, the other members of the jury frequently try, as this one successfully did, to browbeat them into capitulating by saying, don't worry about it. If we got it wrong, the judge will throw it out on appeal. No, they can't, and no, they won't. Those motions are almost never granted. It's a popular misconception, but it's wildly false. And like all the other misconceptions that we've talked about today, all of them systematically skew the process in favor of conviction, in favor of the prosecutor, never in favor of the defense. Surprise number 9. There is a very good reason why we usually require unanimous verdicts. You know the general rule in America, in federal court and in most states, is that in a criminal case and in most civil cases, the jurors will not be discharged with our thanks and sent home until they are unanimous. 11-1 is not good enough, and 10-2 isn't good enough either. Just because the jury is 11-1 in favor of a conviction, it does not mean that the so-called holdout juror is therefore necessarily wrong. Don't make that mistake. Don't think that way. You want some proof? You know, many of us are familiar with Henry Fonda and the famous role that he played in the classic American film, 12 Angry Men. And in that great movie, which I highly recommend to all of you, you remember, I imagine many of you saw it, in this movie, the jury goes back to deliberate. At the beginning of the movie, the trial has just ended, and these 12 angry men in a heart room with neckties go back into a room with no air conditioning, and 11 of them are all ready to convict. They want to get out of there. They want to go home as quickly as possible. And with the risk of spoiling the end of the film for you, sorry, but you had a chance. You could have watched it. Henry Fonda, he reasons with them slowly, gradually. It's with very little cooperation at first, but slowly and ineluctably, he gradually brings every one of them to their senses until by the time at the end of the movie, all 12 of them agree, well, actually, no, the kid is not guilty beyond a reasonable doubt. He brings them to their senses. And the movie was created and written at a time in the earlier part of the American constitutional legal history when we had some sense of how it was that the so-called holdout juror was a hero, a virtual hero. That's why it was a heroic role that was assigned to him. And this is reflected in the constitutional tradition that says that ordinarily we will insist that the jury be unanimous before we will take away a man's life or liberty or his property. Because 11-1 is not good enough. If 11-1, 10-2 were good enough, we'd get them out of there, send them home early, we're close enough, good enough for government work. That's not the notion. The Founding Fathers believed, as our government still does to this day, that if they're 11-1, no matter how close that may seem, maybe they better go back there and talk about it a little bit more because who knows? Maybe that 1 is right and maybe the 11 are wrong. But I dare say that we've lost in America today our sense of that once noble and venerable role played by the holdout juror. Today, when the attorney's here or the judge reports they're 11-1, there's one guy, most participants in the process, the jurors, the other jurors, the judge, the lawyers, the victim and the victim's family, they regard that one as the fly in the ointment, a cog in the wheel, the one who's standing in the way of us getting this thing over with and getting this thing done to get the right result. It must be the right result because the 11 are all in agreement. And we look upon these people disparagingly. And the other 11 back behind closed doors in the jury room are putting all kinds of pressure on that one holdout to knuckle under it and to go along with the rest of us by making all kinds of ridiculous promises about don't worry, he's going to get probation, or don't worry, he won't get life, or don't worry, the judge can throw the verdict on appeal. They'll make whatever promises they think are going to bring this one around to her senses. And she will be subject to tremendous psychological pressure because they will knowingly prey upon her natural instinct to think, well, maybe I'm being unreasonable since they all seem so absolutely sure about it. Let me tell you about the case of Earl Ruffin. There's a picture of him. Earl Ruffin is a friend of mine. He was falsely convicted of a crime that we now know he did not commit. He served more than almost 20 years of a life sentence in a Virginia prison before DNA proved, stop me if you've heard of this one before, that he was totally innocent from the beginning. This man was tried not once but 3 times. He was convicted for raping a woman in her home. A white woman testified that she was assaulted by a black man who broke into her apartment. Nobody in their right mind would have ever thought that this man was guilty of the crime. He did not match the description that she gave the police. She said that the man who committed the crime was much shorter than this man. And he was a very dark-skinned man. As you can see, Earl Ruffin is a very, very light-skinned man. And she didn't tell the police that the guy who committed the crime had a bright solid gold tooth right in the front of his mouth, which this man has. Her description barely matched with this man at all. Her estimate of his height was off by more than 4 inches. But by the time of trial, oh boy, she was sure. She said, there's no doubt about it in my mind. I'm absolutely sure that he was the one. The jury should have known through their common sense that it was really quite improbable that he would be guilty, by the way, because she spotted him at her workplace one day. What are the odds that the man's going to break into a woman's house, sexually assault her in her house, and by the most extraordinary coincidence, they actually work together in the same building? Doesn't your common sense tell you that probably means we've got the wrong guy, especially because he's 5 inches taller than the estimate that you gave to the police and not the same skin color either? But it didn't matter. Just like every other witness who we need, she was good to go by the time of the trial. She got up there and she told the jurors, I'm absolutely sure that he's the one. Well, what happened? At the first trial, there were 9 white jurors and 3 black jurors. The 9 white jurors, all of them voted to convict, and the 3 black jurors all voted not guilty. Hopelessly deadlocked, eventually they threw in the towel, they declared a mistrial. They did it again. Second trial, again. Every white juror voted to convict. Every black juror, there were only a couple that voted not guilty. Again, a mistrial. A third trial. This time, finally, the Commonwealth of Virginia got what they wanted, an all-white jury. They used their peremptory challenges during the jury selection process to get rid of every African-American in the potential jury pool. And that all-white jury, after hearing the same silly evidence, convicted this man in 7 minutes, sentenced to life in prison until 20 years later we found out, oh, whoops, he's innocent. Let that sink in for a minute. 36 different people heard that evidence. And out of those 36, there were only 5 who voted not guilty. The other 31 said, we're absolutely certain that he was guilty of this particular offense. I don't doubt that the other members of the jury thought that these holdouts were being unreasonable. They probably suspected, oh, you're just voting not guilty because he's the same race as you. You don't want to convict a member of your race. No, it turns out in hindsight that although they were a very small minority, 100% of the African-American jurors were absolutely right about this man. So when you find yourself someday sitting in a jury and you've been arguing for days with this one holdout who seems to be quite unreasonable to you, don't assume that you're right and she's wrong just because it's 11-1. And if you are that one, don't be so quick to knuckle under and say, all right, stop yelling at me, stop threatening me. I got to get out of here. Which brings me to my worst and most terrifying surprise of all. This will surprise you probably more than all the rest. Surprise number 10 is this. Under the American legal system and the rules of evidence, if the other members of the jury engage in some kind of misconduct in your presence behind closed doors, for example, they propose to convict a man who seems to be innocent or to acquit a man who's obviously guilty for reasons that are obviously improper and maybe downright unlawful, there's usually nothing the courts can do about it after the other jurors are gone. All over the country, in case after case, every week, every month, every year, from coast to coast in all 50 states, criminal cases, civil cases, federal cases, and state cases, the following scenario plays itself out again and again and again. One member of the jury who was unwittingly assigned the unenviable assignment of playing the role of Henry Fonda is sitting back there in the jury room and is literally incredulous. I can't believe what you people are proposing here. I cannot believe your suggestion that we vote to convict this man for reasons like that. And they argue for a little while, and they protest for a little while, but the others are intransigent, and they say, no, he's not going to go to prison. Don't worry about it. I know he's going to get an ankle bracelet. I didn't tell you about a case. There was a case where a man was sentenced to death by a jury that was told, either you find him guilty of murder and sentence him to death, or life in prison without any possibility of parole. And one member of the jury said to the others, oh, listen, life in parole, that doesn't mean he's going to be, life without parole does not mean he'll be in prison for life. I know a lot of people who got sentenced to life with no hope of parole, and they were let out anyway. And some of them were walking around wearing ankle bracelets. I mean, that information turned out to be totally false, but this information was transmitted to some of the other members of the jury, and they voted to sentence him to death then just to be on the safe side. Again, you don't know what the sentence is going to be, and you can't trust the other members of the jury who think they know. In case after case, though, when this scenario plays itself out, these people who were supposed to play the role of the holdout, like Henry Fonda, and to stand up as tenaciously as possible and to say, no, I'll sit here for 3 days if you want. I am not going to vote to convict this man for reasons like that, which is what they are supposed to do under the Constitution. That's why we insist that we don't let them go until the unanimous. So what do they do instead? The 21st century solution to the problem? Well, our days of Henry Fonda are, sad to say, long gone. In far, far too many, countless hundreds of cases that are on the books in the law library, you can look it up. It's on the shelves right around town. Here's what happens. Again and again, the following thing happens. The guy who knew that the other jurors were proposing something utterly preposterous, he knuckles under. He says, fine, all right, stop threatening me, stop promising, don't stop telling me all these things. Fine, where do we sign? Tell the judge we're unanimous. Tell him we'll vote to convict. And then as soon as the other 11 are on the way to the parking lot, that one runs back into the courtroom, sometimes within minutes, sometimes within hours. Often the next day, he runs to the judge's chambers, or he runs to the defense attorney's office and says, listen, you got to set this straight. You won't believe what happened back there. I'm here to set the matter straight. And all of these jurors, 100% of them, tragically, are laboring under the horribly mistaken notion that we can take care of everything if I just come back the next day. Why don't they just tell the judge about it while the other jurors are sitting there? You know why, and so do I. They are not that good at confrontation. They're afraid. It's easier for them to wait until the bullies are gone, until they've left the room, and then I'll go back and tell the judge. And surely he'll be able to take care of it, right? I don't blame you if you think the same thing, but you would be terribly mistaken, because under the rules of evidence in all 50 states and in federal court, the judge at that point will have no choice but to turn to you and say, I'm terribly sorry. I'm powerless to do anything about this. I wish I could. If I did, I'd be reversed on appeal. I'm not allowed to listen to you. I mean, I can sit here and you can tell me all you want, but I can't grant this man a new trial or set aside his judgment of conviction because of these outrageous things these other jurors did. Let me give a couple of examples of some of the incredible things the jurors have actually done. In the immortal words of Ricky Bobby, this just happened. In one actual case in 1994, a man was convicted of double murder and sentenced to life in prison. He won the right to a retrial, though, because it was later confirmed that 4 members of the original jury consulted a Ouija board before they found him guilty. It was a closed case. They had to make contact with the dead. In Kentucky, more recently, jurors in Louisville, Kentucky, who just couldn't decide whether to convict a man of murder or manslaughter, finally said, let's just get out of here. And they all agreed that they would flip a coin. Unfortunately for him, he lost the flip, and he was found guilty of murder, a coin flip. That really happened. Here's another one. In Florida, 2 young men were convicted of murdering their father. But after the jury was discharged, and they later read in the paper that these 2 young teenagers, not even teenagers, who was going to be sent to prison, the jury forewoman immediately held a press conference where she announced, quote, we never thought that these boys committed the crime, close quote. Let that sink in. We voted guilty. We told the judge we were unanimous, but we never really thought these kids were guilty. She went on to explain, well, why convict? She says, well, we decided to convict them so that we thought the children could be taken somewhere where they could have a new life and learn to be productive citizens, close quote. One more example, yet another example of how it is that in case after case after case, when left to their own devices, jurors naturally and instinctively do the right thing. They take into considerations what little it is that they think they perhaps mistakenly know about what their verdict will mean for the defendant. The Supreme Court has said, and the trial judge told them, don't you pay no never mind what will happen if you vote guilty. Don't you speculate or think or talk about what the sentencing consequences might be. But the jurors, God bless them, for better or for worse, they instinctively know better because they intuitively and correctly apprehend that we can't engage in any meaningful discussion of whether he's guilty beyond a reasonable doubt unless we have some sense of what our verdict might mean for him and for his life. And these people, tragically, were laboring under the horribly mistaken notion that if we convict these kids of murder, they'll be put in a place where surely they'll be taken care of. They were aghast, incredulous that the guy was convicted. Wesley Snipes, the famous actor, recently released from prison. He spent several years in a federal prison, and he's now a convicted felon, in part because the jurors who decided his case made some mistaken assumptions. After he was convicted of willful failure to file various tax returns, not one but two different members of the jury wrote to the defense attorney and reported that we couldn't agree. We were not unanimous. So after several days of agonizing deliberation at an impasse, we decided to broker a compromise. And we decided, well, we'll do this instead. We'll convict him on 3 of the lesser counts because he won't get jail time for that. And then we'll tell the judge we're unanimous. This is not what they actually thought. Some thought he was guilty of more serious charges. Some thought he wasn't guilty of anything. But they brokered an agreement, a compromise. They did the right thing. They said, we'll convict him on this charge because we don't think he'd go to jail for that. Surely not for that. Not for failure to file a return. That by itself can't be a big deal. Well, they were wrong. He got 3 years in prison. And they went to the judge and they complained and said, oh, Your Honor, can we take it back? Can we get a do-over? We'll testify under oath that we didn't think he was guilty. It was too late. It was too late in all these cases. I could give you literally hundreds of examples just like all of these, where these jurors got the biggest mistake, the biggest surprise of their life. And let me tell you about one more case. I've got to give you the name of the case right here. There was one more case. Bo Mastis. He was convicted of murder out, it was when I told you about it a minute ago. He was convicted of murder out in Nevada. And the jurors in that case, a couple of them thought he wasn't actually guilty. And they kept holding out for an acquittal. And when they eventually decided they would vote to convict, that was the case where one of the jurors told the others, allegedly in a bullying tone, that, listen, if we convict this guy, we sentence to life without parole, that doesn't mean he'll go to jail. These people, most of them, end up out on the streets wearing an ankle bracelet. And they fell for it. They believed it. So they changed their vote. And when they found out that they were wrong about this guy and then what would happen to him if he was sentenced, one of the jurors immediately ran to the judge and said to the judge, Your Honor, I can't get over what just happened. This was a terrible miscarriage of justice. I'm in counseling now, this juror said. I am so upset by what we have done. It was the biggest mistake of my life. I'd like to take it back. But you can't take it back. You see? The problem is, people like Henry Ford, I dare say, like the panda bear and the polar bear, are an endangered species today. Once upon a time, the American people generally understood that if you find yourself someday, without warning, suddenly thrust into a jury room and surrounded by a bunch of people that, to your amazement, are proposing that we vote to convict this guy or to acquit this guy for reasons that are absolutely and obviously preposterous, illegal, immoral, your constitutional, it's an unenviable assignment, and you didn't deserve this. It's not a pleasant experience, I'm sure, to stand up to these morons, to these madmen for 3 days in a row and say, I'm not going to vote guilty and convict this guy just because you say he's not going to go to jail, or just because you say the Court of Appeals can throw out our decision if they don't agree with it, or just because the rest of you think this or think that, or because... No, if you know in your heart, if your conscience tells you this guy's not guilty beyond all reasonable doubt, and there's no way in good conscience I can give this judge a green light to send this guy away to prison for God only knows how many years and maybe for the rest of his life, I'm just going to respectfully continue to respectfully and assiduously dissent. That's a difficult thing to do. It's a difficult assignment. Far, far too many people have acquiesced to the perfectly understandable temptation to think, well, here's what I'll do instead. I'll tell the others I'm willing to go along. I'll play along. And as soon as they're out in the parking lot, I'll go rush out to the judge and he'll be able to take care of everything. Surely, right? You can't blame them for thinking this, because almost every day you turn on the TV and there's Oprah Winfrey or some reporter talking to members of the jury about the terrible things that took place there in that jury last week and the outrageous grounds that were accepted by some of them for voting to convict. It's a commonplace in the national American conversation. We've all grown perfectly accustomed to the fact that these things are perfectly fit subject for public exploration and examination. But tragically, what these jurors don't, and you can't blame them because the law is so counterintuitive, unnatural, what they don't understand is you can tell Oprah Winfrey about it, and you can write a book about what happened back there in the jury room, and you can tell the press all about it, and you can put it on your blog. But the only person in the country who is powerless to do anything and to listen to you is the one man who actually has the authority to set aside the verdict. The judge who was actually assigned to the case, under the rules of evidence, he's the only one who's not allowed to give any weight, even if you put it under oath. You can put it in an affidavit, and the press will talk all about it, and reporters may write about it, and the historians may write about this case for 100 years. But the only man with the power under the Constitution to actually give the defendant a new trial is not allowed to listen to you. So what's the solution? The solution is painfully obvious. It's an embarrassment and a national scandal that judges don't do this. We ought to run criminal trials the same way we run weddings. At a wedding, although it's these days more or less pro forma, the pastor will almost always at some point say, oh, if anybody here knows of any reason why these two should not be joined in lifelong holy bliss, speak now or forever hold your peace. There aren't typically many objections that are made at that point. But we ought to do the same thing at a criminal trial. At the end of every criminal trial, the judge ought to turn to the members of the jury and say to them, oh, one more thing before you go. I understand you said you're guilty. You're unanimous. You voted to convict. I thank you for your service. Thank you for your time. But before you go, I just got to tell you one more thing. I have learned through my years of experience on the bench, as every judge has done and as every attorney has done, that there are rare cases from time to time where one or more members of the jury think that they're not really actually in their heart willing to go along with this verdict. They say that they are, but they plan to come back and talk to me about an hour from now, or maybe tomorrow, to call my office, call my chambers, write me a letter, or to call the defense attorney. It happens all the time, and I understand why it happens. But before you go, you need to understand that is not permissible. It is not allowed. If you call me tomorrow, in fact, if you call me in 5 minutes, I'll be powerless to do anything. Before you go, it's not too late. If any of you raise your hand and tell me right now about some reason why you do not go along with the verdict that the foreman just announced and told me that you're all unanimous, that's not a problem. You tell me right now, and I'll either send them back to deliberate some more, or I can declare a mistrial, or I can grant a new trial. I'll do whatever it takes to make sure that no injustice is committed here today on our watch. But you've got to tell me now before you go. That's it. Just speak now or forever hold your peace. That simple little device, which as you can see is exactly what I would do if I were the judge at every trial, would completely take care of the problem that right now is leading to the unjust conviction of hundreds of people every year, even though the jury, truth be told, wasn't actually unanimous, but one of them was afraid to stand up to the others or gave up after a couple of days of trying, mistakenly thinking that all could be set right if I go to talk to the judge tomorrow. Why don't we tell the jury about this? It's such an obviously sensible solution. And tragically, the answer is because we are busy and we want to keep these cases moving. And judges know that if we tell the jury about what I just told you, there's inevitably going to be a greater chance that some of these members of the jury are going to hold out tenaciously to the very end because they know that's the only way to do this. And then we're going to have more hung juries, and that means more mistrials, and that means more retrials. And that's something that judges don't want to do if we can possibly avoid it. And so we are knowingly perpetrating a system right now where we keep jurors intentionally in the dark about the fact that they can't come and tell us about problems after it's over, and they can't come back and tell us about it tomorrow because it'll be too late for us to do anything about it. We don't tell them that because that's how we keep this system going. That's how we keep these trials getting over with, because we know this leads to acquiescence on their part, submission on their part. That generates a higher level of so-called unanimous verdicts, and then we can stamp this case closed, 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 next case. And then hundreds of times every year, these jurors come back the next day and they get literally the greatest and gravest mistake of their life when the judge says, I'm terribly sorry, I could have done something yesterday. I know you say he wasn't guilty. You never would have voted to convict if you had known the truth. I'm sorry. I wish I could do something about it, but I can't. And if I did, I'll be reversed by the Court of Appeals. But I'm not a judge, so I can't tell the jurors about it. So I'm here today in the beautiful state of Idaho, making this little video that's going to go viral. And eventually, God willing, there's going to be, this will be my concluding thought. I'll wrap it up with this. God willing, I foresee that there will be several new chapters in the future of the American criminal justice system in the near future. Chapter 1, the first chapter, which starts tomorrow, there'll be no change in the way that we do things because it'll take a while before the word gets out to literally everybody in the country. Chapter 2 will be when this video was so widely read that thousands of people all around the country start sharing with the other jurors these 10 little top secret surprises that I have shared with you that anybody could learn for themselves if they had just made the time to go browsing through the books over at the law library. And that'll cause a great deal of frustration for judges all around the country because the information that we have tried so hard to desperately and intentionally keep the jurors from learning. So that'll lead to chapter 3, where judges all around the country will start saying it during jury selection. Now, folks, we got to ask you if any of you have seen a video about a talk that was given out in Idaho a couple years ago. Because if you've seen that video, we're going to get rid of you. And that'll be a sorry chapter in American criminal history until chapter 4, which is also described in the book of Revelation. Chapter 4 will be when judges all around the country ask, did you see that video in Idaho? Oh, yes, I did. Oh, yes, I did. We all did, Judge. What are you going to do? It's too late. We've all seen it now. You can't get rid of all of us. And that'll be a very happy day in the history of the administration of American criminal justice. Thank you very much for coming. Good night.